You're welcome back, and let's get right into it. My guests in the studio right now are J. Kwabena Bonfe, Junior PhD. He's lecturer at UPSA and CEO of Census. We're joined on Zoom by Maria Awalana Ada, and we have Victor Kojoga Adawudu. He's managing partner, Lord and Lord's Legal Practice and member of the NDC Legal and Communications team. These days, he's involved in reforming the law. Kofi Bento, a good friend, the rebel, lawyer and senior vice president, Imani Africa. Nana Ejay Bafo Ewa, Rebel Plus this week. Vice Chair, Subsidiary Legislation Committee and member Constitutional and Legal Affairs Committee of Parliament. Now, I was with you in the Supreme Court. We were sitting together and chatting. I finished my process. I was leaving. You also finished quickly. You joined me. I asked you where you were going. Say, I'm entering that place to do something. If you had told me this is what you were going to do,
something. Something.
I would have kept you company for longer.
Something. You know, you and I have had a lot of private conversations about how I think our judiciary must be reformed. We've bottled a lot. We've bottled a lot in over a period of time.
True.
And so when you have people like us come out in the manner which we came out, you know that it's not in a
most
vacuum.
Unusual.
It's most unusual. It couldn't have been without provocation. You see, there was a time in the Bible, Jesus entered the temple with a whip. And for me, the best example, excellent leadership, is the leadership of Jesus Christ as a Christian. It tells you that there are times when something should be done out of character to change a system. Unless something is done out of character to change a system, then we are going to go with the status quo. Nothing will change.
True.
Nothing will change. I mean, how can you have a situation where somebody even makes a bail application and the judge can say, not in connection with the one that got me provoked, then the judge can say, we are adjourning for 2 weeks. And then adjourning for 2 weeks to rule on the bail application, and the person should go on remand. So it tells you that a lot.
We'll get to that discussion. But since I have some good lawyers here, what do you think? Some say that is an indictment on those judges. Looks like they're unprepared, or unless they are up to something deliberate. Mere bail application, and you adjourn for 2 weeks. Someone's liberty is at stake. You adjourn for 2 weeks. If you won't grant them the bail, just don't grant them. So they take a decision what next to do.
Something that is the ideal situation. That's what ought to happen. In that, when you make a bail application, you can even make an oral application. You don't need to, in the first instance, to put an application in motion.
We really never. It's always oral.
It is sometimes when you finish the first one, you are refused. Then the next one, you come with an application.
Right.
And these days, I think one of the things that the judges ought to be doing, and must be
some
doing.
of the judges.
Yes, some of the judges.
Because they are judges.
Even most.
They are judges who will not even wait to listen to you. Once the plea is taken, they say, I am minded to grant bail. These are the terms.
That is why
wait for you to talk.
Yes, exactly.
Judges
yes.
We shouldn't say judiciary.
That's the point.
Going forward, we should single them out.
When we discuss
that's the point I'm getting to. That you see, the act of preparing and giving bench ruling, because it is presumed that the law is within your bosom. So whilst the facts you have read and you see the issues as this one, I have to grant bail, without even the lawyer arguing, because you have read the processes already. But where some judges would come in, they are not prepared, they've not even read, and after the ruling, whilst bail should not be used as a punishment, they come and say, okay, can we adjourn, and I'll go and come. Once you know very well that while somebody is in custody, he cannot be there more than 14 days, 2 weeks. Then you ask him and you say, I'll give the ruling 2 weeks to determine whether...
You are the Law Reform Commission.
Oh, yes.
You're supposed to be reforming the law.
Exactly.
Is this one of the things that will, get your attention?
Yeah, there are a lot of things.
There are rules. There are rules about how to go about it.
What I see there is a disconnection between the Law Reform Commission, the Rules of Law Committee, and Parliament. There is no coordination and complementarity.
Okay. You ensure that, Kofi.
So my brother Adaudu, this should concern you, and there's this disconnect, but work it. You see, you say bail should not be a punishment. It's a matter of rights and all the things that we know. Okay, it should be the rule that you are going to be giving bail, and the exception rather should be argued. So that's another matter. Samson, we all have been part of what you are discussing, and
the Constitution Review Commission has actually treated this, including investigations that take forever and prosecutions that take forever. Yes. One of the proposals I put before them was that there should be timelines for prosecution. Yes. If you can't do a prosecution over 6 months,
you leave it.
You may ask for permission to get about 1 more month. If you can't finish it, let the person go.
Yes.
And investigators, as we understand, can say they're investigating you for years. They will seize your passport. There are people who are complaining about their passports being seized all over the place. And for years, they are holding on. And their life has come to a standstill.
I think Martin Prebu settles that matter.
So we are
when Benin says that there is no time frame for investigation, you cannot hold the person, so you can't just come and say investigation continues. Why did you arrange the person before court?
When you are not ready.
When you are not ready. When you have been given the power to grant bail.
We should resist the urge to give complex reasons to things when simpler reasons will suffice. And I'm saying this because, look, we are beating up the issue of why should somebody say, I'm adjourning to give a ruling on bail. It is deliberate. It's a plan. Don't give a complex reason when the simpler one will suffice. The person knows that they shouldn't do that. They are using some sort of arrangement to make sure you are remanded. Why would you adjourn for a bail hearing? And when we hear some of the things that have happened this week,
and bail is discretionary, right? Exercise of discretion.
It is discretionary.
You want to think about the discretion you want to exercise over 1 week or 2 weeks.
Exactly the point. So, we here understand. Even though it's discretionary, it's a matter of rights. It should not be used as punishment and all those things, which is why the law reform people should make sure that is the rule. The exception is what should be argued. So I'm saying, look, the judges are our friends.
Right.
All right. We sat with them in class. We give them the names of God. I tell the young people all the time, when you sit before a judge, that person is not the guy you knew. He's called my Lord. Worship. All right. Because they have the power of life and death in their hands. And for that reason, we defer a lot to them. But it is also true that sometimes they take things so far, it becomes absurd. And the simpler reasons will suffice. In this particular case, sometimes you may not like the person, and for that reason you punish them. It's not right. It is not right. Do substantive justice and let us proceed with it. And let the system run.
Thank you. Doc, you've been observing this. What do you say briefly? Because people were really angry that a speech offense, which for a long time we have said there's a problem with the speech offense. Of course, we will be discussing where to draw the line, because to be frank with you, some people just abuse their right to speech. Right.
So true. So at the heart of this is the issue of public trust, which is anchored in the work and the relationship that exists between law enforcers and those who adjudicate, and in this case, the court. And all these must be seen by the people. At the heart of what is done at the executive level, the judiciary and the legislature, is how the citizenry decode what we see. Now, if we cannot have trust of fairness, of consistency, of principle from the courts, but that one would sit as my Lord, as your worship, and decide that he will look at Ajay Balfour's face and give judgment, look at Kwabena Bonfa's face and give judgment, then where do we go? And this is where I like to refer to what former Vice President of the United States, Hubert Humphrey, in his small book, this small book, The Cause is Mankind, at page 25. He says, the law can be no better than the people who are called upon to administer or obey it. So it is duty, imposed on us, especially those who have been called into the revered or elevated office of adjudication, to ensure that we can have trust in what they do. And lastly, I think it is incumbent on the bar. I mean, the judges don't cease to be members of the bar when they have, the association of the bench. So when they meet and there is interaction between the bar and the bench at the unofficial level, what kind of conversation takes place? And this is where I think we need to nail it and make sure that we live up fairly with one another. Thank you very much.
Maybe I start with with you on the OSP. Justice Eugene Nyante Nyadu has been top in the news since, was it Thursday or Wednesday? He says, I hereby order the Attorney General to take over all prosecutions currently being handled by the OSP. That was after he had declared that the OSP does not have a warrant of the Attorney General to conduct prosecutions. And so the prosecutions it has done, the convictions it has done, they are void, and the prosecutions that are pending in the various courts, he's ordering that they should be taken over. The Attorney General says they are taking steps to do that. And in fact, they are ready to give the OSP the authorization if they apply.
First of all, this conversation that has occupied the public space within this week is, in my view, not an isolated case. Indeed, there are other issues involving the IOCO, which used to be Serious Fraud Office, that fall under the same perimeter. The FDA, GRA, immigration with powers to prosecute in their various acts that establish them. So what is happening for me is a symptom of how we are living as a people within a state. And you look at 5 key things: the law and parliament, the occupants of office of public trust and their conduct, the constitution as the parent law, the people generally as citizens, and then the principles that are supposed to guide us and how we somersault or flip-flop our positions with regards to that. These are the key things. But I want to precede my submission with 3 quotes. First, from Benjamin Franklin, who in 17 September 1787, at the convention that adopted the United States Constitution, after all the deliberations and the terms, he said, on the whole, sir, I cannot help expressing a wish that every member of the convention who may still have objections to it would with me on this occasion doubt a little in his own infallibility and make manifest our unanimity, put his name to this instrument. So they came to adopt a constitution not without faults, but that they will work with it and improve upon that. Indeed, less than 5 years, in 1791, they had the first amendment. Second, Maya Angelou says in her book, How I Know Why the Caged Bird Sings, that it is not, people will remember you for not what you said or did, but how you made them feel. And lastly, the quote that I gave from Hubert Humphrey, that the law is as good as we the people. The conversation about having a separate office from the Attorney General has been going on for a very long time. I have in my hands here this lecture that was given by Vintage AKP Kluje in 2010, J.B. Dankwa Memorial Lecture. and he dealt with the Office of Attorney General at page 143. This is what he says. Of late, there have been a debate on whether the Office of Attorney General should be separated from the Office of the Minister of Justice. And he goes on to deal with, some of the issues that people have raised. Then he adds this at page 145. In Ghana, we have the tendency to blame the system whenever it does not work to our entire satisfaction. We then demand that the law be changed or the system be restructured. To me, it should not be too much whether the Office of Attorney General is unified with the Office of the Minister of Justice and held by the same person as the present arrangement ordains. What matters to me are the personalities of the main officials and their commitment to good governance, the rule of law, and advancement of the protection of fundamental human rights, human and civil rights. This is what he says. And he goes on to deal with various suggestions, including possibly electing the Attorney General at popular elections and the various nuances that are with it. Samson, if you recall, in 2018, when this OSP was being discussed, I penned an article and I made a quote, or I said something that I shared with you yesterday. And I said, we'll come to this point. Because in 1993, when the bill establishing the Serious Fraud Office was being discussed, the late Justice J.N.K. Taylor offered this article in the Legislative Alert about the unconstitutionality of the Serious Office. The arguments he advanced suffice in this conversation.
Unconstitutionality of
the Serious Fraud Office,
now
which is now
Yoko.
And they are in tandem with what is happening at the OSP. But you see, what I find strange is the unprincipled nature of some of the key actors in this matter, particularly the Attorney General, Dr. Dominic Ayine. Of course, Dr. Srensai held brief for him in representing the Attorney General. But the key person is the Attorney General. When they were passing this bill into law, go and check the parliamentary records. His contribution to making it come to effect and be seen as curing the call for a referendum, as some of us held, because we felt that that law, in its strictest understanding, would be amending Article 88, which is entrenched.
I thought that his stance then aligns with the present position taken by the plaintiff in the suit in the Supreme Court, and for which they have filed their submission supporting that.
Which is that? Did you read about the something they call standing authorization and delegated authorization? Who introduced those words? He. And because of his academic credentials, it was taken. And that is why, if you look at his conduct, including entering nolli prosequi in some cases that he was counseled for, when he had not become Attorney General, beg of his consistency to principle. And I don't think people in public office should go that line. At the end of the day, the consistency of your arguments tell the credibility that one should have in you. Then the whole conversation about if indeed we as a people believe the Office of Attorney General is not good enough to help us fight corruption and we want to change it. Nobody forced us to adopt the Constitution in 1992, which came into force in 1993, to say that there are provisions in the Constitution that are entrenched and that you cannot amend them through parliamentary legislation or subsidiary legislation, and that you must go through a referendum. If we are so inclined or we so strongly believe that we must amend them, why don't we go through a referendum? Why the haste? And then we change it and we come full cycle in this kind of arguments. For me, I believe that we as a people have not been faithful to the Constitution and to the law. And that's why we are going around in this. Then it comes to the people who are occupying the office of Special Prosecutor today. Just this morning, I think one of the lawyers for Dr. Hamid Abdul Mustafa has contradicted a post by Samida Akum. And you wonder why the haste to put out information when you are going through a certain process of law. Should the law argued in court be put out in the media as if the courts are disabled, or if you like, not fully fit to deal with the matter head on. Must we fight the matter that should be fought in court in the media? I think that also comes to the fore. But largely, the article penned by Martin Amidu is of interest to me, which is that he is not surprised at this suit. And that even when he was invited by former President Akufo-Addo, some of the issues regarding constitutionality, he raised them. And the president assured him that, well, let's leave that to the courts to handle when they come up. And he picks or paints the picture of both the negatives and the positives in the whole conversation going on. But he picks on the Attorney General's conduct, particularly. And the courts, for declining, the attempt by the OSP to join the case pending at the Supreme Court. So, again, Samson, it comes up. I read the judgment of the High Court, and with the greatest respect to those who know better, I think it was an application of quo warranto, which the High Court is properly seized with to be able to pronounce on. Did he exceed his limits or his powers? I think there's a matter pending before the Supreme Court, and perhaps if the Supreme Court is minded or the attention is drawn to it, they will bring the matter to a possible conclusion. I want to conclude that at the end of the day, we as a people must choose and accept that once we have adopted constitutional democracy, the burden of democracy is fidelity to the law, even when it inconveniences us. And that nothing else can compensate for any attempt to disobey or short-circuit the process of the law. Thank you.
You mentioned the Attorney General and suggested that his position today is inconsistent with his position when the bill was being discussed, including the debate on the floor of Parliament on the 1st of November 2017. I read to you the Hansard, what he said.
No, it was settled.
He rose to, the Speaker asked if there was any objection to claims, suggestions that had been made, especially by Mr. Banda. Mr. Banda has said that, Mr. Speaker, I beg to move clause 4, subclause 2, line 2, before authorize, insert B. I would read 4.2, the rendition is, now he quotes, subject to clause 4 of Article 88 of the Constitution, the office shall, for the purpose of this act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. This is what you have in the law now, Section 4. Thank you. Then Dr. Ayini rose, and the Speaker asked him, any objection? This is what Dr. Ayini said. Mr. Speaker, I wanted to propose a further amendment because we have not indicated the mode of authorization by the Attorney General. So I wanted to propose that she is authorized by the appropriate legal instrument. Remember, it was Gloria Kufu who was pursuing this. General. Then Mr. Speaker, Michael Kwe came in and said, where appropriate, legal process of authorization means what? Dominic returns, Mr. Speaker, for instance, she could do so by constitutional instrument or by legislative instrument. Please note that because we may return to it in the debate, in the discussion. How do you authorize the special prosecutor to prosecute? Attorney General's proposal, now Attorney General, his proposal, Dominic Ayini, was this. She could do so by constitutional instrument, that's a CI, or by legislative instrument, that is an LI, where it will spell out clearly what the jurisdiction of the Office of Special Prosecutor is. This is because what we are doing here is to say that Parliament is by statute making the Attorney General authorize a special prosecutor, but she is the one who is delegating that authority, and there has to be a mode of delegation. Mr. Speaker, that is the point I am making. I'll just read the Speaker's response. What kind of authorization are you anticipating again? The person has been established by an act of Parliament, and you are going to ask the Attorney General to start authorizing, bringing in matters that lawyers describe as quo warranto? Now remember that what has led to the decision now is quo warranto. It would become a big issue. By what warrant? By what authority? Let us not create unnecessary problems. If the special prosecutor is established to perform certain functions, are we intending somebody else to give him a warrant to start that which the Act of Parliament has given him, or to do, or her to do? What authorization? Let us be careful so that we do not open unnecessary Pandora's box. This is because issues of quo warranto, lawyer, you know they can be very long-winded. He said, yes, Honorable Chairman. Then he calls in Boabeng Asamoah to speak. So his position is not contrary to what he had stood for.
So what I'm saying is this. At the end of the day, they endorsed the office with all the sections in the statute that created it, which included the principle of what they called standing authorization, or what do you call it, delegated authorization from the AGs. He was a part of that committee. And I'm saying to the extent that he was a part of that and they approved of it, I don't think the OSP Act was approved by Parliament through majority or split vote. It was unanimous. True?
Bipartisan consensus.
Exactly. So that becomes his then adopted principle or position. And I'm telling you that at the committee level, before it came to the committee of the whole, these terms of delegated authorization, how to navigate the problem of going to a referendum to amend Article 88, and I think before the Supreme Court, they will even consider whether or not that statute or that act amounts to an amendment of 88. It will all be discussed. We leave that to be discussed at the appropriate forum. All I'm saying is that as people in public trust, there must be some consistency. Okay. You cannot today go around and say that the OSP, as it exists, that you approved of, could not or cannot do what it is doing.
Unless with your fiat.
Unless with your fiat. And that's what I'm saying. And that means now coming to join those of us who held the view then that the parliamentary path that you were taking was wrong and you couldn't cure the issue we're raising.
Let's find out if the parliamentary path was in fact wrong and needs any cure. But let's not forget that what happened in the courts was not the deed of the Attorney General. It was not a case in which the Attorney General was involved. It was a special prosecutor prosecuting Archibald. And Archibald felt that the special prosecutor doesn't have the authorization.
Quo warranto, yeah.
Quo warranto, where is your authority?
Yes.
And began the inquiry,
yes,
and led him to file an application
properly at the High Court,
which the court now determined. So hold on.
No, but please let's put it on record. Who went to defend that suit? The quo warranto. Who went? Did the Attorney General not?
Office of Special Prosecutor. It was against them, so they went to defend it. Not the Attorney General. Not the Attorney General. Okay. Yes, Kofi.
We must be clear in our mind.
Quo warranto.
It's really
you, the SP. Do you have power?
Well, yes. It's for the gentleman to use that. That's what we lawyers do. Look for something in the law to defend your client. But the bigger issues around this are principles.
Yeah.
What we must appreciate is that, especially in when reasonable people are speaking, people have different views. when you encounter a superior argument, you abandon yours. That's what Parliament is for.
See.
Parliament means a place to speak, a place to debate. People come with different ideas. So it's okay to put out the ideas, okay? But when you encounter a superior argument, what a reasonable person does is abandon theirs. Now, when you abandon your ideas, it doesn't make you a fool. It makes you better.
Sure.
But when you pick the superior argument, you don't go back to your argument. It's a matter of principle. Okay? Many people have called me and said, why am I describing Dr. Ayine as my brother? I've known the man for 30 years. He's my brother. Justice I, very fine lawyer. We can disagree. It's not personal. It's not a fight. But on this matter, you and I know the position that Dr. Ayine took. And he argued it very well. And he was consistent on it. But here in this Hansard report, it is clear that he met a superior argument.
And conceded.
And he conceded it. Now, we were all there. This was the main issue. The authority of the OSP against 88 was the main issue. Why it hadn't been done in the past, why it was difficult to do, and we're all saying we should do a constitutional review, and then we say we can't wait for a constitutional review. That was the main issue.
That's right.
Yeah.
And so
Here was the main issue, the memorandum. Read here and read here. You can read.
the establishment of the Office of the Special Prosecutor has become necessary in view of the institutional bottlenecks that impede the fight against corruption.
Mm-hmm.
The monopoly of prosecutorial authority by an Attorney General who is hired and fired by the President has been singled out by the governance experts as one of the key factors that stand in the way of using law enforcement and prosecution as a credible tool in the fight against corruption. The establishment of the office for the purpose of prosecuting corruption cases involving public officers and politically exposed persons in the performance of their functions will undoubtedly yield positive results in the number of corruption cases prosecuted. That a multi-purpose or mixed mandate agency such as the IOCO, the bill therefore seeks to vest the special prosecutor with the authority and control required. The bill seeks to vest the special prosecutor with the authority and control required to effectively investigate and prosecute cases of corruption and restore public confidence in the justice delivery system and by extension government. Why do we...
He just read the memorandum to the law.
So this was the main issue, all right? And we were clear-eyed about the fact that 88 was a problem. Yeah. We all decided this was it. And so in writing, and you know, Dr.
Some still held a view.
No. When I say we were all, I'm saying after the arguments were made, and they were not easy.
Yeah.
In civil society, everything ended up in Parliament.
Yeah.
And you see the speaker. The speaker had this position. And he came to the point, and he was saying, look, let us not argue about these things. It is deemed that the person is authorized. That's the whole purpose of the thing.
Sure.
And if you leave any room, when Dr. Ayine was saying, let's use the EI, CI, or whatever, we're saying if you do that, that means every time the guy is going to prosecute James Bonfe or myself or whoever, he has to go for authority. That is a total negation of the whole thing.
Independence.
So this was the issue. Superior arguments were made, and therefore people abandoned their position. Now, you and I have sat here before, and we have talked about the attempt to remove the OSP or abandon or kill his office. And we've made the point. The people who it is aimed at are the ones trying to kill it. Now, if therefore they want to kill it, any excuse is useful.
Yeah.
So look, again I say, when a simple reason suffices, we should not strive to put complicated reasons around an issue. This has been an ongoing effort. The last one failed. All right? It came up. It went to Parliament. The president had to step in. That failed. They've come around. They are going back again at it. All right? People have made the point about the occupant of the office. That matters. Yeah. That really, really does matter. Even in the matters of bail and whatever it is. The law can be one thing, okay, but the conduct of the person gives energy, this way or that way. So that's an issue. But I think that can be resolved one way or the other. But let us be clear about this. There is no controversy. This is made up. Because this was argued, it was settled, the law was written, Section 4 is there. Yeah. And the interpretation of Section 4 is that the person has been given authority as in a running authority. Now, for interpretation, you can say it whichever way you want. So now, this has been resurrected for the purpose of achieving a certain goal, that was the status quo ante. Before the OSP, this was the status quo. AG couldn't do anything. They are stacked up with cases, and people had interference in the cases. You can't, prosecute somebody you are sitting in cabinet with, and all those other things. Then we made this point. They are going back to that thing. Why? So please, let's not confuse ourselves about some esoteric law. This is a simple matter.
Professor H.P.C. Prempe and the likes are that the purpose of the act is defeated if the authorization has to come by a fiat from the Attorney General, and that in fact, apart from the purpose of the bill of the law, sections 4 of the law, and regulation 11 of the legislative instrument duly vest that authorization. He doesn't need any further authorization.
Yes. And all those gentlemen were part of the discussions. And they were heavy.
The judge disagrees with you.
Well, the law is in his bosom, but judges make mistakes, and sometimes they make terrible law. Very terrible law. And the name of the judge has been put there. I don't want to go into, him per se, but clearly this was wrong. And you know what? People are talking about, it was a quo warranto issue that came.
He's not alone in that view.
No. But of course, he's not alone. But you see, judges don't make law. Parliament makes law.
They interpret the law.
They apply.
Let me finish. They don't make law. Okay? We know that even though judges don't make law, sometimes there is judge-made law.
Yeah.
Because they have certain powers.
Exactly.
I am making the same point. Maybe that judge was on that other side of the argument.
Correct.
But once it has been debated, and sometimes people feel like the debates are unnecessary, you talk too much or whatever. This is the reason why. You beat it on the left, beat it on the right, beat it in the center, and then you draw a conclusion. You abandon the other one. And if you're a judge and you felt a certain way, once Parliament debates it and comes to a conclusion, you are duty bound and legally bound to follow that. Now, if for any reason you made a mistake, it is for us to sit here and say, well, you made a mistake. Nobody has insulted you. This was bad. And if you are dealing with a quo warranto issue.
My suggestion to you is that there may be as many who support your view as there may be who do not support your view and support the judge's view.
Agreed. But what I'm saying is that, you see, when you have a written institution, and that's why we have these memorandums, okay, it gives you the thinking behind the law. That's the duty of the judge. Me as a lawyer, I will argue one narrow part in the interest of my client. But the judge, you don't like this, you don't like death sentence. Read the memorandum, read the law, read other cases, read, views of other people. And that's what I'm saying. When a superior argument is advanced, you abandon your position. Look, I keep repeating this thing about the Occupy Ghana versus Attorney General, Auditor General case. That the Supreme Court, seeing a law where the interpretation was clear that the person may exercise a certain discretion, given all that was going on. And that is why you bring other things into the judgments you made to make them whole. Judges have to read around, okay, get a sense of it, the memorandum, etc., and bring it into the judgment. Sometimes you read a judgment and you are like, wow. I have lost cases before where I read the judgment and I'm like, this makes sense. So that was the duty of the judge. And where your quo warranto hits a constitutional issue, which was under interpretation, the Supreme Court was seized with it. You have to step back and say, hey, let the Supreme Court make that determination. So I agree that people may have different views.
The Supreme Court has been invited to make an interpretation of the Constitution.
Yes.
As regards Section 4 of the OSP Act.
Against it, yes.
In the High Court, there is no an interpretive question that came up. The judge was being simply asked to look at the act and apply it to see whether the SP or the OSP has the warrant authority to prosecute.
Yes. And he looked at the act.
Yes.
And like I said, he should have read the memorandum. And then he should have read the act and seen Section 4. He should have read the LI and read them together. He should have read some of the things around. And when people talk about cases in court should not be discussed, I totally differ. The more you discuss cases, the more the judges get perspective.
No, that judge is now functus officio.
I know. I'm making a general point. I'm saying that he should read around. The lawyer's job is to make a narrow argument. Even if he knows better, make a narrow argument in the interest of his client.
You are suggesting.
So, wait, let me finish.
You are suggesting.
No, let me finish. I haven't finished the point. When the judge read all of these things and understood them, how could he come to the conclusion? Because these things working together bring you to the irresistible conclusion. When we say irresistible, it means if you put 10 people there, 8 of them will agree in a certain direction. So how could you read all of this and come to that conclusion now? If you did, then we can sit here and say, I don't know how you read this.
Okay, so the point of my intervention has changed, because I was going to ask you whether you were presuming that the judge has not read these, because it's obvious that in the process and in the arguments, these laws were argued by the Office of the Special Prosecutor, and the judge actually took note of them, but took a decision. Whilst those of you who say the judge's decision is application, is incongruous if you look at the whole purpose of the OSP, which is it has to be independent. It needs independence of function and prosecution. When you look at the purpose and everything else and you say his decision is incongruous with the law and the purpose, you are suggesting that the judge is saying the entire law is bad. But what you read the judge say, that you may have a good law, but one small problem, how to authorize the office is the problem. So the judge may not be against the entire architecture of the law.
Because there are what we call material particulars. Every big tree has a tap root. This is the whole fulcrum of the thing. The anchor of the whole law is the authorization. And that, like I said, that's the main issue. It wasn't a tangential issue. This is what we discussed for years. We beat up, we had arguments, philosophical arguments, legal arguments, and then we all decided, look, it is not there. Okay, 88 says prosecutorial authority belongs to AG. And I'm telling you, that thing that we borrowed, some of them, these are colonial relics. In the US, they have quitam processes. Individuals can go and sue people for corruption, etc. When they win, they share the money, like whistleblower. If we were thinking about our own circumstances, etc., we'll be going that way. But we just borrowed something. And that thing, there's a reason why they got there. We had all these arguments, and then we ended up saying that, okay, we are going to give a special prosecutor, a special authority. And it was written, described in the memorandum, written in the law, and then the LI put it out properly. We've used it for 8 years. Okay? And I wonder, how come in the reliefs, he also goes back to quash previous convictions? Okay, I don't.
No power to
it gives me a sense that this person was on a mission. All right. So my point is this: he has the law in his bosom, but he has the responsibility to read broadly and widely, and to explain it such that we will not have cause to sit here and say this was a bad decision.
We'll come to interrogate the question, and I don't know if any of my other guests is going to raise that, which you just raised, and Dr. Bonfe just, made a comment that he doesn't have the power to have done so. I've heard the comment about high courts have coordinate jurisdiction. So you have one high court that is sitting on similar matters by OSP that says, as for me, I'll wait for the Supreme Court. But he decides otherwise. And some say his decision cannot bind the other high courts and so on. We'll look at that. Yes, you have been itching to make your point.
Something. There are a lot of issues arising from this. And you would not be able to get a head or tail of it unless you drill down on all these issues. This whole matter arose by reason of the originating motion that was filed. In my humble view, there was an issue of jurisdiction. On Wednesday, I had an opportunity to appear on PM Express. At the time, I had not gotten some of the processes. When you look at the second relief, you see, when you have an originating motion, for the purposes of your viewers, for the benefit of your viewers, that is what invokes the jurisdiction of the court. That is what determines whether the court has the power to determine the matter or not.
When a court does not have jurisdiction, everything it does is
It's a
null and
nullity,
void.
yeah.
Okay.
One of the prayers that the applicant made, that is the second relief, was on a true and proper interpretation of Article 88.
It is here. A declaration that on a proper interpretation of Article 88.4 of the 1992 Constitution and Section 4.2 of the OSP Act 2017, the OSP may prosecute only subject to and upon authorization by the Attorney General.
So that's what triggers the Supreme Court.
That is distinct from the enforcement powers of the court. They are two different things. The moment you go in for interpretation of the Constitution,
Supreme Court,
it is not within the remit of the High Court. It is within the remit of the Supreme Court, exclusive jurisdiction of the Supreme Court. I've heard people say that who said the High Court doesn't have the power to apply the Constitution. Whether or not you are going for an application is determined by the prayer or the relief you are seeking. So the moment your relief is couched in the manner of a declaration for interpretation, then the High Court doesn't have that.
The judge disagrees with you completely, and he cites plethora authority that vest him the power that this is not about interpretation, it's about application, and he's done that job. And you are by this suggesting that there is grounds for the OSP to appeal.
That's right. There is really an issue of jurisdiction. It is determined by how you couch your reliefs, because it's an originating motion. If it was a writ, and you were seeking declarations on a writ, it is within the general jurisdiction of the court. But the moment, even in that circumstance, there is a prayer for an interpretation, then of course it's not within the jurisdiction of the court. The judge may disagree, but this is my view. Indeed, if you look at even the case of Espati Kubaji, is it Kubaji? The Supreme Court, that was one of the reasons why the Supreme Court commended the Circuit Court judge for making the referral to the Supreme Court.
Yes, Raphael Kubaji.
The court didn't want to, the Circuit Court, didn't want to be caught in a controversy like this. And we are saying that, look, if it was a question of enforcement, because you had gone for quo warranto. Quo warranto is to say that what power are you acting? By what power are you acting?
And by the Constitution, by our rules, the High Court has the power to issue those writs, prohibitions, quo warranto, certiorari, under its supervisory jurisdiction.
For you to have
this is what was invoked.
Quo warranto is a question. It's a question.
Where is your authority?
Where's your authority? And so if you know the authority, you wouldn't have gone and asked that question. At that point, the OSP hasn't told you the authority by which he's acting. You are saying that what authority? So wait for the OSP to tell you the authority by which he's acting. Then in your reply, you posit your argument that I contend that you don't have the authority by these acts.
In fact, this is exactly what brought this motion. Yes. Because they have sought to challenge the OSP's authority. They ask, we know that all other persons prosecuting or institutions prosecuting prosecute under the warrant of the Attorney General. Where is yours? And then the OSP said, ours is in our law. And then he said, no, that cannot be the purpose. Okay. And then they said they went to search and they found that there are executive instruments for Yoko, for all the other people, which is the fiat by the Attorney General, but there was none for the OSP. On that basis, they mounted this. So that question you have just asked, in fact, is what brought this.
So I suspect that at the point they were asking all those questions, they were doing it orally. And so now you bring a formal application. When you bring a formal application to ask that question, at that point, you don't seek interpretation. Let the OSP tell you what power it is operating with by their response. Then in your reply, you can contend, and the court will rule. But when you are asking by way of a relief, you are seeking by way of a relief, an interpretative issue, I very respectfully think that it was outside the remit of the High Court by way of jurisdiction. So let's move on. With all that having been said, I still think that the Attorney General hasn't really done the nation, some fairness. And I'll tell you why. Everybody knows my position when it comes to the OSP. It's a principled position, right?
You were fighting it so it doesn't arrest your clients.
No. It's far beyond it.
Right, I get that.
It's far beyond it.
Okay.
I am looking at the economic value, and I'm ready to debate anybody on that subject.
I'll debate you after.
Don't worry. I'm ready to do that. But, Samson, when there's a proverb in Chi, you say, "Yedi jawa, ni yedi aswao." So when you take the office of the Attorney General, you take the good, the bad, and the ugly. You take the good, the bad, and the ugly. And you take a position to defend everything associated with Ghana. Okay? In 2001, 2002, thereabouts, President Kufuor was the president of the Republic of this country. We all know that under the Courts Act of the Republic of Ghana and indeed the Constitution, there's only one High Court. The Chief Justice has the power to create divisions of the High Court. The Chief Justice consequently creates a division called the Fast Track High Court. It is challenged. It is declared unconstitutional by the Supreme Court. The President could have folded his hands and said that, look, after all, it's the creation of the Chief Justice. Let the Judiciary defend it. They created it. But he didn't sit on his oars. He decided to go on a full throttle to defend it because it was an asset of the country. When Godfrey Dami...
How did he do that?
Court.
Through his Attorney General. Right?
Except the circumstances, sort of.
But the circumstances
about appointing a Supreme Court judge.
Two other judges.
Is that new to review? He went through the process. Is that new to review?
He went through the process.
No, they were fresh appointments.
No,
they were necessary appointments.
They were not new appointments.
The Constitution requires that on review, the panel must be augmented.
That's right.
At that point, there were no judges.
Whatever it is, your point is made.
Yes.
He defended it.
Yes, Samson, he defended it. Right? When Godfrey Dami became that, during the
Gloria Kufuor.
Gloria Kufuor was Attorney General. And the appointment of Martin Amidu was challenged by the current Attorney General.
Age-wise.
Age-wise. The Attorney General defended it. You see, Samson, when you look at what has happened, the OSP has been left alone in the battle. And that for me is improper. It doesn't speak well of the office of the Attorney General, especially on the back of some of the reactions that have come subsequent to the decision of the court.
Or it reveals an intention.
That the best you can do in the circumstances to take over his cases.
It reveals an intention.
Two things.
The Attorney General didn't ask for this. Let's remember, this is an individual who went to the court.
And the Attorney General was not a
This is not the Attorney General.
the High Court.
This is an individual
Consistent with this in the
The AG says so.
No. Was it part of the...
I just want the records. I just want the records to bear out. I just want the records to bear out that there is a gentleman by the name.
Arguments at the Supreme Court.
There's a gentleman by the name Peter Archibald Hyde who is being prosecuted and who brought this.
The public. It is not because Attorney General was not part of the
Nobody
case.
is saying that.
Samson,
You take your turn.
I'll take my turn.
Wait, Samson, you see, they've interrupted me. So when you say you take
No.
I don't think Samson, I've been fair. But Samson, wait, this is it. All that the court said, whether we disagree or agree, whether we think that there's a jurisdictional question, it still remains the decision of the court. Whether it is of coordinate jurisdiction, it remains a decision of the High Court. Even though, as I said, it might not be binding on the other high courts, it may be of persuasive.
It might not, or it
doesn't. It doesn't. I want to always be very cautious in how I do my analysis in the public.
So when you say it doesn't, it means that the other high courts that are doing the prosecutions, they will continue, but the order is to the person of the office.
It's when you
don't have the fear to continue.
You may be in contempt. And that is why it's one of the reasons why I think the court went overboard. And because of time constraints, I can't go into all these. But this is it. The court's decision, whether we like it or not, is binding on the actors. What the court decision really and truly means is that in the absence of the Attorney General's power, you can't prosecute. Fiat. You cannot prosecute. Yes. So all that it takes to cure that in the present circumstance is to give him the fiat. Now, between the giving of the OSP the fiat and the taking over of the OSP's cases, the Attorney General's immediate reaction is to take over the cases.
Reveals a lot.
Choices.
The Attorney General says, we are ready to give him the fiat, to give the office the fiat if they request.
That is where that was subsequent. Wait, I'm saying that indicates to you the intentions of the Attorney General. That fiat must not be asked in the circumstance. And what are the circumstances? The circumstance is such that the OSP is already prosecuting the cases that the OSP has investigated. Cases that the OSP knows more than the Attorney General. He understands the cases more than the Attorney General. And you say you are taking over to go and do them, understand them from the scratch, to go and do them. When the OSP is in the middle of it, between yourself and the OSP, who is much better placed to do those cases? You choose to take over those cases because of what?
As a lawyer, don't you take cases midway and prosecute them successfully?
I'm saying, already the AG's office is struggling to even deal with its own cases. And you have somebody that the state has voted a budget to work. You say that your immediate reaction, you cannot divorce this from a certain history. The OSP's crisis with this current regime started with the arrest of Martin Pebu. It was after that that senior members of the ruling party decided that the office must be abolished. Move was even made to pass a private member's bill to achieve that end. Indeed, commentaries that came in were to the effect that if you touch one, you've touched us all. And so that became it was at the heart of it. It took the intervention of the president following pressure by civil society for them to withdraw. Subsequently, we are thinking that, look, Samson, what is going on, really? People know that is to achieve a certain end. An objective that could not be achieved through the abolition, they think it can be achieved by weakening the office. Because when all it is required for the office to continue with the 8 cases that it is doing is to give it a fiat, you prefer to take over the cases. You know, there's
who tells you that the OSP is willing to accept a fiat?
I know you are playing a devil's advocate, but Samson, in every situation there's a transitional process. What is the AG's transitional plan for what has even happened?
If you say the OSP should accept a fiat, does that not defeat your argument that there's no need for a fiat when you look at the way you made the law as Parliament?
I haven't come to that. I will come to that. And please.
Your time is up.
Yes, Samson, but I mean, add 2 minutes because of the interruption by my friend.
Dr. Bonfe did 14 minutes. Kofi did 14. You are on your 15th minute.
But interruption, 3 minutes interruption. Please allow me. Quickly. Samson, 1, we need to appreciate that the Constitution is the parent law of this country.
That's right.
Any other law which is inconsistent to the Constitution, no matter the intention, no matter how well it was intentioned, will be unconstitutional. Now, if you also look at Article 93, 2 of the 1992 Constitution, Parliament's power to make laws is limited by the Constitution. And so it doesn't matter the intention. If Parliament errs, Parliament has erred. There is a fundamental problem with Section 4 of the OSP Act. Even if the court in the future would have to say that by reason of certain steps that were taken by the AG, particularly the LI, that power was given, the power which is anticipated under Article 88, 3 and 4 was given. I don't think that the court will save Section 4 of the OSP Act unless the court is prepared to consider the shall in there as may, as has happened in some cases. And I think that we may need extensive time. And so that's why I'm being very... Yeah. But my view is that Article 8 and Section 4 of the OSP Act is a compromise position that could not achieve the ends
it was negotiated.
That it was that had been hoped for.
Okay, thank you. So, Victor, I'm bringing you in now, but Dr. Bonfe has to take leave of us, so I'll give him a couple of minutes final comments, then he leaves us to continue. Of course, we have Mary Awalana Ada also on phone, on Zoom, waiting for us. But since Section 4 has been referred to too many times,
3 or 4.
Section 4 has been referred to too many times, Article 88 has been referred to too many times. Last week, I read them out. Let me read them out again for your education. Now, this is Article 88 of the 1992 Constitution. Article 88 of the 1992 Constitution says, there shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government. 2, the Attorney General shall discharge such other duties of a legal nature as may be referred or assigned to him by the President or imposed on him by this Constitution or any other law. Now, 2 important provisions here, 3 and 4. 3, the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. 4, all offenses, again, all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with law. This is Section 4 of the OSP Act. It says, except as otherwise provided in the Constitution, the office is not subject to the direction or control of a person or an authority in the performance of the functions of the office. 2, subject to Clause 4 of Article 88. Clause 4 of Article 88. Remember, Clause 4 of Article 88 says, all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with law. So, Clause 2 of subsection 2 of Section 4 of the Act says, subject to Clause 4 of Article 88 of the Constitution, the office shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses.
So by this,
and then you have a legislative instrument made in 2018, also under the hand of Gloria Akufu, the Attorney General then. That says the special prosecutor or an authorized officer shall, upon considering the facts and evidence gathered from an investigation, take a decision whether or not to prosecute. Yes.
Well, my concluding remarks on this would be that at the end of the day, a law was duly passed by Parliament.
And it's binding on this government.
And it is still part of the laws of our country until it is said to be inconsistent and null and void to that extent on the powers of the Supreme Court as Article 2 grants. That hasn't been done yet. If it will be done, I don't know. But I foretold that we'll come to this point when that act was passed, that it could be questioned, and if it was questioned, there were two scenarios that would be out. And just to crave your indulgence, Samson, this is what I wrote in 2018. I did write that we are only sitting on a time bomb for any accused person to challenge the constitutionality of the law that created the office when the special prosecutor begins his work in earnest. Whatever the outcome of such a case, the effect on the office would be dire for our constitutional process. If such a case is thrown out, it amends the Constitution regarding the amendments of entrenched clauses. If it is sustained, the whole process, time and other resources expended, would have been a waste and blow to the fight against corruption. Most often, such processes which fail the test of the rule of law are a product of political haste and attempts at populist show rather than seeking institutional transformation. I don't want to believe that my prediction then is coming to pass, but I would pray that the Supreme Court grants the OSP the chance to join that interpretation suit before them, because the Attorney General has given us every assurance.
They ruled already.
But he can join with the latest development.
Yeah, no, I'm saying that was their earlier application.
I think that's useful information.
So, but you can come as amicus.
Yes, it's useful.
No, he can. If there's a development, it's an interlocutory application.
They can reapply.
You can reapply.
They can reapply.
All service organizations.
You are right. I'm saying
as amicus.
it's useful to add
Better apply as amicus.
I know
and
that.
matter.
Relax.
Bobby Banson, who
Relax.
teaches civil procedure,
Yes,
told us here last week that this is a new development,
Which they can-
because at the first instance, the Attorney General said, I am the Attorney General, I can defend.
Yes.
the
And so
acts."
far, it is.
And the Supreme Court said, let the Attorney General defend. Now they have realized that the Attorney General's defense is rather in support of
the applicant.
Plaintiff. So it's a new development. He can go back. The OSP can go back
Exactly.
and ask to join.
Exactly.
Can go back. Hold on, I beg you. Can go back doesn't mean he has gone back. We are urging it. Number one. Number two, earlier on, there was a motion for a joiner, and it was ruled that it is not necessary for that person to join for the case to be done. So the Supreme Court actually said, no, we can go ahead without the OSP. Now, new things have happened, which mean the OSP can if they choose. I'm saying all I'm saying because if you are the OSP under this kind of siege, you would advise yourself whether to proceed or not to proceed. It is proper in the interest of this country and all the things we've done that the OSP joins. So whether they like it or not,
Thank you.
we think they should.
Thank you.
They should.
All right.
Yes.
You finish.
So I'm not done. Mr. Martinamidu makes a point, and perhaps the Supreme Court of Ghana may be persuaded, I'm quoting, may be persuaded by the grounds on which the U.S. Supreme Court upheld the constitutionality of the Independent Counsel provisions of the Ethics in Government Act 1978 in Morrison versus Oslon 487 U.S. 1988. So that is an appeal to the Supreme Court for them to have, a very fair view. Samson, my comment on the issue about arrest and all these things is to make these 3 points. One, that the right to free speech is not one that is unfettered. We must be guided, we must be careful, and we must be civil in the comments that we make, not to exceed. That is one. Two, the law enforcers cannot all of a sudden attempt to bring back criminal libel law, all in the name of some people are exceeding their rights as speech. In fact, even if they exceed their rights as speech, the avenues are there through civil procedure to deal with it. And the conduct of some of our police officers, I'm saying some advisedly, is very much unbecoming. That they think because they wear the crown of the state, they can do as they please. It is not right. And sometimes the judges endorse that kind of act through some of the things that we were earlier discussing. And so I want to plead with the pleading of former President John Agyekum Kufuor in a particular case that President Mahama's first coming, that do not kill a fly with a sledgehammer. Even though at the time President Mahama replied in a way that was not, in my view,
It
appropriate.
doesn't matter that the fly can conduct itself in a way that can destabilize your society.
No matter what it is, the fly is not capable of conducting itself in that manner that will destabilize the state to the extent that you have to use a bulldozer.
Okay, so because you are commenting on this, let me ask you one straightforward question. Do you approve of the things they are accused of? Number one, Baba Amando, the accusation is that you've seen it. He went to pick their images and, use whatever AI to clad them with gay
Is that a crime?
material.
Samson.
One, do you approve of that?
I don't.
You heard Abronye's comments. Do you approve of them?
I don't.
So what do we do?
And I'm saying there are avenues in dealing with such matters to serve as a deterrent.
But this is one of them.
And I'm saying it is not true the manner in which we are doing that you remember when the Kenofurata matter came here, we sat here, and you see what I said then has come to pass? It has come to pass. Sometimes we are in a haste and we destroy ourselves.
Okay.
Sometimes we must be measured with the way we go about it. So lastly, Samson, we are in the World Autism Month. And next week, the Nature's Sprout Academy is doing something for the awareness. I want to say, as a disability researcher, that disability is not a taboo, neither is it a disease. It is a human condition, and we must be tolerant to dealing with it. That's it. Thank you very much for the opportunity.
Thank you very much.
And I wish you all the best.
Thank you very much.
Samson.
Once again, hold on briefly. Because you have finished your submissions, my attention is being drawn to something by those who have been in the office that we are talking about, not the OSP's office. They asked the question, when the nomination of the SP is done by the Attorney General,
Yes.
and the appointment is done by the President after vetting by Parliament, what is the implication? Do you need further authorization?
It won't cure a constitutional breach.
No. The question
A
is
constitutional breach is a constitutional breach.
no.
The fact that somebody who has occupied a particular office has acquiesced to a breach, it's not a defense to a breach. The fundamental question with Article...
What was you? Let's say you are Attorney General. You are picking an OSP, an SP. What are you picking them to do?
Samson, the Constitution...
What are you picking them to do?
picking them to go and serve in the office...
Serve by doing what?
By implementing the act.
How?
Wait. Wait. When the Constitution says that the Constitution is the supreme law of the land, and any other law which is inconsistent with it is, or an act or deed or omission is null and void.
Who determines that?
Wait.
No.
Samson. Wait.
This is supposed to be brief. It's,
Samson.
Yeah, you are coming.
Samson. Yeah. The Constitution has given power to the Attorney General. When you look at the provision of Section 4 of the OSP's Act, there's a compulsion on the Attorney General to delegate his power to the OSP. The fundamental question, which is the elephant in the room, is whether or not you can compel a constitutional office holder, somebody with a constitutional responsibility, to delegate his constitutional mandate.
okay. So see,
It is far-reaching than we see.
the law says,
It has
the
consequences.
Article 88 you are referring to says he can do that delegation by certain means in accordance with law.
No, writing.
so let me do my quick.
So what's the
Can
use?
he be
Wait. So what
Can
is
he
the
be
use of the law?
compelled?
What is the use of the law? And what is the use of the...
What?
Wait. How different, okay, or which is superior? A legislative instrument, this LI, or an executive instrument, which is the fiat?
Samson.
Which is superior?
Samson. what is in issue?
Please answer my question. Which is superior?
Samson,
because when they were arguing,
what is in issue is what the legislative.
When they were arguing,
The issue is Section 4.
No, let me do this. When they were arguing,
yes.
When we read Dominic Ayene's comment at the time, he said, let's prescribe the mode, either by constitutional instruments or legislative instruments. This is a legislative instrument.
Correct.
Those who say the judge's decision is wrong, they are pointing that to you. It's Ankuma and the rest. They are pointing this to you.
When you look at just the legislative instrument, with the greatest of respect, you make an error. The legislative instrument sits on an act. That act, which is the Section 4, you cannot divorce it from the legislative instrument. The fundamental question is the constitutionality or otherwise of the Section 4.
So the fiat.
When you resolve the Section 4,
please listen carefully to yourself. I'm using a legislative instrument to do something I can use an executive instrument.
You've moved on from Section 4.
No, wait.
Have you moved on from it?
Still in Section 4.
Now.
Wait. They were discussing Section 4, where the suggestion was that use a constitutional instrument or a legislative instrument. You may say this legislative instrument, the provision is terse, it's not sufficient enough. But those who argue in favor of the fact that you don't need further authorization say that a legislative instrument like this one, signed by Gloria Akufu, Attorney General, is superior to an executive instrument, which is the fiat.
Wait.
Because this one is oversighted by Parliament.
You cannot divorce it from the act, which is Parliament compelling the Attorney General to delegate his power. You see, when you look at Article 106 of the 1992 Constitution, the lawmaking process is not defined to include the sponsor of the bill. If it had been defined to include the sponsor of the bill, we probably have a different interpretation. This is Parliament-made law.
Thank you. Yes, Kofi.
So, for the education of the public, an executive instrument is an act of the president. It is binding on the government. When the president goes, it dies with it. A legislative instrument sits on an act, a law, statute passed by Parliament. If that law goes, that legislative instrument goes. A constitutional instrument is pursuant to the Constitution. So, point number one, an executive instrument is not binding on the next government. But a legislative instrument is binding on all governments.
It is pursuant to
Oh, please,
an act
I beg you. As long as the act remains, the word compulsion has been used. It is the AG that has the power. Madam Gloria Kufu, having her power, put the law out. She went to Parliament. This idea that somebody compelled somebody, she drafted it, put it there that this person shall be authorized, and said it in a way ambulatory. It's ongoing. There were discussions which have been recorded. It is pursuant to the memorandum and the things that followed.
He's telling you that Gloria Kufu has fettered the discretion of Dominic Ayene. He shouldn't do that.
Which is why I explained that as long as this law is law, it binds all subsequent governments until you repeal it. That's why we have NRCD laws.
Where is the discretion you have given me if you have used a law to say that I have given part of it to somebody else?
That's the purpose of law. The purpose of law is not to give people discretion to do this or that. It is to tell them that after we all thinking through something, this is what must be done. Which is also why it must be consistent. Which is also why it Let me finish. It's important to say
there is Victor, there is Mary.
If you don't like the law,
if
you don't like the law, please, we are talking to the public. If you don't like the law, there is a room, there is process, and this government has 2/3. Go and repeal the law.
The president said
as long as the law is
you
there,
shouldn't repeal the law.
That's what the point. So the law is active.
Thank you.
So you are bound by
so Victor,
no compelling.
Victor, hold on.
3 hours now.
Yes, I take a quick break. When I return, we are going to hear Victor and Mary Ada.
Important in the long title for our purposes is when you say prosecute these offenses on the authority of the Attorney General. Which Attorney General? Where then is the independence that you promised? We will say that the appointing authority, the president shall appoint the special prosecutor or a special counsel, as it is in other jurisdictions, with the prior approval of Parliament, and probably even further recommend with 2/3 majority, so that the person is a strong personality who is subject not just to executive nomination but prior approval of Parliament. We also must strongly recommend that an addition to the remit of the Office of the Special Prosecutor must be recommendations of Parliament based on the Public Accounts Committee report, so that the leakages, misappropriation, embezzlement also can directly be punished by the Special Prosecutor. Is an act to establish the Office of the Special Prosecutor as a specialized agency to investigate specific areas of corruption involving public officers and politically exposed persons. Who are politically exposed persons? If you want us to subject election processes and officials engage, even political parties say so, but when you say politically exposed persons, I have a difficulty. But Mr. Chairman, even what is more important, in the performance of their functions as well as persons in the private sector, we've roped in persons from the private sector implicated in the commission of corruption. And when you bring in the private sector, there is always an ambit, a platform to commit corruption. Nowhere in this bill is the other twin evil, bribery, mentioned. Yet they go together. One reinforces the other. And therefore, nepotism, favoritism, bribery reinforces corruption. But
its mandate directly from Article 88 of the Constitution, and that article is the one that vests the prosecutorial powers of the state in an Attorney General. Now, do you envisage a situation whereby the functions of the Special Prosecutor would conflict with the functions of the Attorney General, given the fact that these are functions largely derived from the constitutional powers bestowed on the Attorney General?
Initially, I would like to believe, Honorable Chair, that when this process started, you could tell that there was a clear and happy friction as to how it was going to go. And so some of us even pointed out to the then Attorney General, informally then, actually, that, I mean, as a lecturer of criminal law, when you see some of these things, you would have to tell those in authority as to how things should properly go. There was a concern of this friction between the Attorney General and the OSP under Act 959 because of the way Article 88 has been couched. Because it gives all prosecutorial powers to the Attorney General, but then, by way of delegation, the Attorney General can delegate a person or institution to carry on prosecutions. So what the draftsman did in Act 959 is a sort of taking that discretion and that Article 88 from the Attorney General, putting it in Act 959 and saying that the OSP can prosecute on the authority of the Attorney General. It is stated in the Act. And so by that formulation, from the onset in the Act, the OSP already has the authority of the Attorney General because Parliament has said so. But that would not end the story if more delineation is not done. So it appears tenuously, but the draftsman also tried to do something in Act 959 by specifying the offenses the OSP can investigate, can initiate, and conduct prosecutions in respect of. That is corruption and corruption-related offenses.
All right. So you heard Haruna Idrisu very long ago. That was when he was minority leader. And then this process was done. And for those of you who followed the process, I'll confess, the OSP Act, the memorandum, and the processes about it, I've read them. I know them like the back of my palm, yeah? The guys who, I keep saying, who midwifed it, even though it was the Attorney General Gloria Akufu who was leading the process because it was her job, Dominic Ayene, Haruna Idrisu, Inusa Fuseni, and Mahama Yarga. These people were critical, and yet they sought to contribute to refine it, and we got it the way it is now. Of course, together with Chairman Sabonsu and his friends. Now, let's hear from Victor Kojoga Daudu.
And let me say that we are specifically, there are two issues on the OSP. And what we are dealing with now is the ruling that we've had from the High Court. Right. So that we do not mix the two issues. Because people are mixing the two issues and saying that the court did not have jurisdiction. No. The court actually had jurisdiction to deal with this matter. And the court does not derive its jurisdiction based on reliefs you put before.
That I disagree.
No. If you read Sangbari there, it tells you that you can couch the relief in any how. And I'll come to the interpretation issue.
I agree with you.
It doesn't mean that the kind of relief you have put would confer that court with jurisdiction or will not confer it with jurisdiction. The court will have to look at the relief, even if one, it does not have that relief, it can try the other reliefs.
The court will look at relief. You're still talking about relief.
Yes.
Right in saying is the relief.
No. So it is not to say that the High Court did not have. It had. And what the High Court did was to apply the law. And once he applied the law, did he have, under the law, to issue that direction order? If you look at Article 140 grants him the jurisdiction. You look at Article 141, also grants him that jurisdiction that he can issue orders, direction as to the direction that all the cases to go to the Attorney General. You may have problem with it, but did he have that legal backing?
What kind of problem is that? You may have problem with it. What kind of problem?
No, that all the cases should be taken over by Attorney General. But in the same vein, he says that they can continue to prosecute when they are given the authorization. And the good thing is that Attorney General says they are ready to issue the authorization. So I commend the judge for being bold. He was bold in applying the law to the facts. And at the center of all this was that, where is your authority? Before you prosecute, your law says that you must be authorized. Come and show that authority that you have to. And you were not able to show it.
No,
and
they showed. The court disagrees.
No. What they showed, that it was their law.
Yes, because it's a standing for them.
Yes.
The law, as you heard Kiseja being in that vetting.
Yes.
The Act, Section 4, is a standing delegation authorization.
Yes.
And then I am told that in their argument, they also refer to the LI as well.
The LI. But the court says that, based on precedent, if they say any authority, right, what they had come to see is that the EIs that have been given to other officers or institutions. So he follows the precedent and say that by his understanding, when they say Attorney General should authorize any person or institution, it should follow as the EI. That is his understanding. He might be he might be right, he might be wrong. But I think that he's been bold, he's not been timorous, and he has spoken that this is how he understands the law. You may like it, you may not like it. 2, Bafo made an argument that the Attorney General has not been fair with citizens or this nation, that they did not put in any argument against this matter.
That's what I said.
No, you said no. So
that's not what
that's why I just.
If you are quoting, you quote me right.
So what did you say?
I said 2 things. 1, I think that the Attorney General is not taking the necessary steps to protect the office. And I made reference to the President Kufuor's instance with the fast-track High Court, and I made reference to Gloria Kufuor's defense of the office. I've not seen a similar spirited defense.
So his reference will be relative to the
Supreme Court
case.
And that's what I'm saying.
That's what I'm saying.
Post the decision.
No, that's what I'm saying. That in the High Court matter, Attorney General was not part.
Post the decision.
So how do you expect Attorney General to enter the matter and argue? Because out there, it will seem as if he knew and conveniently decided not to be part of the case. But in the actual fact, he was not part of the case in the High Court.
People are asking you is this.
Yes.
Even if the Attorney General was part, it cannot be argued differently, because it has already told the Supreme Court that I agree that they don't have the power.
Exactly. Right? Now, in the Supreme Court, Samson, you're a lawyer. I'm a lawyer. When you concede to a point that is being made, does that mean that you have to, you know the truth? This is how my thinking is. This is what the thinking of the plaintiff is. And I agree, not entirely with him, but essentially I agree with him. Is that to say that I'm not putting up a forceful defense?
You are a lawyer. There are several ways of handling this matter.
No. You see, the way you want us to go is that, you see, that's had a problem, like the 2 examples you gave.
Because what he's saying is not far-fetched. Yes. When I started my practice earlier, and even in moderating this show, sometimes it's difficult not to take a position, and stick to it at the earlier stages. Now, I sit here and I can act with complete disinterest, but I'll moderate. When I go to court, I would have argued a narrow point and insist. But today I can go to court and say, the judge is prompting me on something. I concede.
Yes.
Yeah, you don't lose anything.
So
yeah, go on.
So are you saying that we cannot concede
whether or not there's even a constitutional question at the Supreme Court?
So it is that from what he's saying, you see, that they forcefully defended during Kufuor's time. At the end of the day, what was the backlash? What was the perception? That you were tinkling with the law, or you were trying to compromise the Supreme Court. That was why you had this verdict. And you are also, so it is for the people to look. I don't think, let the law lords speak the law, what they see. And interpretation is different, as they were talking about the memorandum and the rest. Yes, I agree. This was the law. But from day one, something I can tell you, when they started with the memorandum on this law, I'm sure we met together at Alisa. I remember I was one of the representatives of the NDC with Koku Anido, who at the time he was the Deputy General Secretary. Some of the points that were raised up to Article 88, those are the things that is manifesting today. It was a good law. It was a good intention, but its implementation was a problem. And they knew at the time that it was an entrenched clause. They will have to go to constitutional amendment, right? The process by which they will have to go through referendum and be able to take that Article 88 and give some power to the OSP. For political expediency, they were not ready to go through that process.
It was a bipartisan consensus. What has happened to that today? That's
now,
what the
so if it was a bipartisan consensus, and the Constitution is supreme, are we saying, for convenience, that all the lawmakers and people have agreed, citizens have agreed, that this is what we want, but let's bypass or circumscribe the law And at the end of the day, we've been caught in the web.
Your point is that
Right?
you
Is
are
it-
you are backtracking. You are changing your position for
I'm not changing my
the
position.
bipartisan consensus.
No, I'm not changing.
Okay.
I'm saying that if by partisan consensus we have agreed, the lawyers, the people, everybody has agreed that let's circumvent the law, let's be able to go and see the OSP functioning. And at the end of the day, this matter has been raised that it's unconstitutional.
Let's be careful. The bipartisan consensus was not a circumvention, like there's some attempt to do wrong.
No, it wasn't an attempt to do wrong.
Bafo is telling you that if you took that position and agreed,
Yes.
you have a duty to defend that position and not to now sort of
Yes. So that's
betray
why-
the consensus.
No. So that is why something now Supreme Court will look at the memorandum, look at all the aids to interpretation, and would give us an appropriate interpretation, just like.
But there is a betrayal of the consensus.
No, it's not a betrayal. You see,
The
we have
betrayal is
agreed.
that the AG is in the Supreme Court saying, I agree with the plaintiff. The OSP doesn't have authorization.
No. The executive, legislature, they have agreed. There is a consensus as to what we need to do. They make the law. Now you have brought the law to the judiciary. The judiciary is to look at it, whether this provision
I understand.
is
So my point is
consistent
that
or inconsistent
now
with the Constitution.
defend your consensus position. You are not defending your consensus position.
But you see, in that consensus, where he made that there was superior arguments that were made, right? That draft or doused the argument that were being made at the time by the minority. That what was the mode of the authority? And the speaker rightly said, listen, we should not allow this quo warranto and the rest to derail the process if we look at the mode. Now the same thing has come back to that, what is the mode of the authority? And they are saying that the mode of the authority is their law. And the court is also saying that the mode of the authority should be an executive instrument.
You are referring to Speaker Michael Quay.
Yes, Speaker Michael Quay.
Did you hear him in the course of the week?
Yes.
Journalists asked him
Yes.
what had happened. Did you hear what he said?
Yeah, he said that that was right. Right? So we knew the problem.
Can you compare that to what he said at the time?
Yeah. Was he being true to the principle?
There are people now that people are questioning them, and some are actually using insulting language. It's not right.
No,
you can criticize people without insulting them. Aiko Otu has said, "Oh, we saw the problem sort of." Pemka, who was also in the AG, said, "So we saw it sort of," and then Aiko Otu says, "I couldn't have intervened to do anything." Meanwhile, your intervention is here, clear.
Written.
All of you superintended this process.
Yes.
Then suddenly you are saying, "Oh, we knew it." How?
So if the majority knew fundamentally we had a problem, right? They were not bold to speak to it. And today, a judge is bold to say, this is a problem. Judge has said it. Now we intend to condemn him for speaking boldly to speak. He has just applied the law. And there's avenue that when maybe the Attorney General, as we are saying, can enter the matter or take it on, right, and say, this is my view. But it looks as if...
You mean the OSP or the Attorney General?
Oh, the OSP. The OSP can, with the new development, and if you look at the case of the Ghana Bar Association versus Attorney General, the Nene Amegache, their case on the issue of advice, it got to a point the Supreme Court even says that it might not be necessary that every day the Attorney General should represent other institutions when they matter. So if OSP, based on the issue where Attorney General said, I can defend the OSP, and we've seen the development now, I believe if OSP goes back based on the development or civil service organizations go in, I'm sure they will be allowed.
So call for the OSP to go back.
That decision lies with the OSP.
But you make the call.
They know the facts. They know the evidence, what they have.
The judge said,
I am an observer.
The judge said, any convictions,
Yeah.
That was serious,
if any,
overboard.
secured by the respondent as a result of the purported exercise of prosecutorial power is hereby declared void. And I order the trial of the persons convicted to be commenced de novo by the Attorney General, pending the OSP applying to the Attorney General for its officers to be authorized to conduct
Attorney General should be concerned.
The issue of the necessary executive.
If you look at the statement that Attorney General has put out, he's not concerned about these things.
No.
It's about taking over the files of the office.
Mention one case.
My question. Here's my question. Here's my question. After reading this, he declares all convictions void.
Void, yes.
Then says that AG should take over and start them all over, right?
Yes. That is where I have a little challenge.
Let's hear it.
The challenge I have is that, one, he has the right legally to make an order.
Without a
He can issue orders, he can issue direction based on Article 141, right? 141 and Section 16 of the Court Act. He has that power to issue any order to any direction. But that order and direction, you should look at the effect and whether it will stabilize or destabilize the system. And one of the cardinal points for the court is to bring about social cohesion. And also
the legal question people are asking, which is what I was actually asking.
I'm coming to that.
The legal question is, you declare that somebody didn't have the power to initiate something.
It's just like capacity. You didn't have capacity.
So void ab initio.
Void ab initio.
Meanwhile, the AG was part of some of those cases.
So you cannot be asking that something should be started because it didn't exist in the first place.
Yes.
So it's gone with the wind.
It's gone with the wind. And that was when, if you read the judgment, he comes back quickly and says that those proceedings and other proceedings, until they have authorization, then they can continue with those. But as you say, it is void by his order. Those proceedings and others are a nullity, right?
If they are a nullity, they are a nullity.
They are nullity.
They cannot be continued.
Yes, they cannot be continued. Now he says that for OSP to start any prosecution again, they should have the authorization, right? So it is not the case that OSP is being terminated or disbanded. What he's saying that, yes, it's an office. If you can investigate, you do it. But if you want to prosecute, make sure that you have an authorization.
The question,
right?
The questions that arises, legal questions, are these. That's a high court. There are other high courts that are doing OSP cases, right?
Yes.
In fact, this court is not the substantive court where the case is being heard.
Exactly.
Right? So perhaps this court doesn't have an OSP matter. The question that people are asking is, in law, the other judges, are they not entitled to say, you can't say our thing is void because you don't have power over us?
Exactly. Because of their coordinate jurisdiction. So until this his ruling, so he cannot bind the other high court. Until this decision...
He binds the parties.
No. Yes, but that is what he's saying. So the other court can say that, look, I'm not bound by the decision in that matter. So in anything we have to do, let's look at the interpretation that would come from the Supreme Court.
So you should have waited.
Now, was notice given to him? You see, judicial notice. No. Was notice given to him that there is some aspect that is dealing with this issue of authorization, which has to be interpreted by the Supreme Court.
If you read the ruling,
yes,
it talks about a preliminary legal objection that was raised.
Yes,
and then matters including that it is the Supreme Court that will have to deal with this.
No, just try. Yes, no. The issue is that they wanted the interpretation, reference to the interpretation. And that was where he said that, they said he didn't have jurisdiction to do interpretation. And he said that by republic and mankind, which laid the principle that.
No, stick to your question.
No.
Your question was,
Yes.
did the judge have notice that this matter, this portion, actually is pending before the Supreme Court? No. That's the question. That's the question.
Yes, he did not.
Really?
From my ruling in this matter.
We are told that this matter was adjourned how many times?
No. From my ruling, from the ruling I've read.
Right.
From the ruling I've read, the preliminary objection was on the interpretation.
No, the time.
Preliminary objection.
The time, its first was mainly on the time the
time was
the
the
time
second
the supervisory jurisdiction was invoked.
Yes.
Which the law provides the timeline. They said they had gone beyond the timeline. The guy said, no, we are not looking at when he was charged. We are looking at when we discovered that
notice
that they don't have an authorization. And then the other issue.
The other one was the jurisdiction. Now, when it came to the jurisdiction, that was where he referred to Smala Bill and Menkankai and says that, yes, lawyers or human ingenuity and the rest, you can craft any relief. And that once you craft it, you would say that it's a constitutional issue and it has to be referred. And he made reference to Bonfes case, right? No, wait. Yes, he made reference to Bonfes case where Sophia Adinira at the time said this, if you may permit me, let me read. The real test as to whether an issue of constitutional interpretation is whether the words in the constitutional provision the court is invited to interpret are ambiguous, imprecise, and unclear, or cannot be applied unless interpreted. If it were otherwise, every conceivable case may originate in the Supreme Court by the stretch of human ingenuity and the manipulation of language to raise a tangible constitutional question. So he said clearly that he was not, but you don't craft an issue.
You have done over 20 minutes now.
Okay.
I'm going to Mariada. Gentlemen, I'm sorry. I'm not allowing any one of you to interrupt. I'm going to Mariada now. Mary, thank you very much, and thanks for your patience. You, the CSOs, now you are being blamed that you all were rushing and you were not paying attention. All you wanted was a special prosecutor, as if that was a magic wand, and you didn't have the patience for the law to be done well. What say you?
I believe that would be one of the most unfortunate conclusions that would have been arrived at by anyone. But before, let me say hello to all the other panelists and yourself in studio and those watching. We had an issue, and the challenge was navigating the fight against corruption with the current architecture we find ourselves in. And civil society had, through our advocacy and through the various researches we had done, come to the conclusion that the fight against corruption could be achieved if we had a better alternative. And that better alternative was separating the two offices, which we have not been able to achieve because of the issues around constitutionality and all the instances the lawyers have been espousing for the past almost 2 hours. So what was the other good practice or the consensus position we could come to ensure that we didn't allow the plundering of the state to go unnoticed or to go unpunished? We did an extensive research, and something you were part of this, if not from the beginning, perhaps somewhere along the line. And we came to the conclusion that some offices exist in other jurisdictions which were doing a good job. And apart from that, if you looked at the first NACAP document, it proposed something along the lines of an independent
National Anti-Corruption Action Plan.
Yes, the NACAP proposed an independent prosecutor, not what we have now. And that NACAP was originally initiated by the current president. And it went through the processes, getting all our support and putting in this document to ensure that we fight corruption very well. Unfortunately, we didn't get that. We had manifestos come up where the past president, Nana Addo Dankwa Akufo-Addo, suggested the office of the special prosecutor, which I must say was not similar to what the NACAP wanted, but they were supposed to be killing the same bird. And so civil society believed that to ensure that this happened, we needed to support the process and not to support it hook, line, and sinker. We came up with evidence, research that puts together this law, and we support it and still believe that until such a time that we are able to navigate the challenges of the Constitution, this was the best bargain we could come up with. Unfortunately, some of the proposals we made, which were not accepted, if they were accepted, would have cured some of these mischief that is currently being perpetuated. We agreed that there was no way we would have this independent office without dealing with the issues around Article 88.4. And so our proposal originally was to ensure that we have a constitutional instrument, if not whatever the case may be, to ensure that we have some stability. But the persons you have mentioned earlier, who were part of this discussion, who stood against some of the proposals civil society came up with, we came to a consensus because we believed without a doubt at the time that we needed something else, because the fight against corruption was being done post-regime, and post-regime accountability is not exhaustive enough. We thought we should have a wholesale in-regime, post-regime accountability regime that deals with anti-corruption. And we came to consensus. The Honorable Banda, who was the chair of the Legal, Constitutional and Parliamentary Affairs Committee of Parliament at the time, and all the committee members and others who came to join in, including civil society as a coalition, believed that this was the way to go. And we did same with ensuring that we have a law to fight corruption. And over the past 8 years, Samson, let me say that even though we have not had a perfect structure, we have seen some gains. And let me quickly bring in the assessment which was recently done, which you moderated the session so perfectly on. Some of the issues that came up, which citizens continue to believe and which civil society believes is credible and must be thought of, is the fact that citizens believe that the OSP continues to remain relevant if the executive allows it to be so. And citizens believe strongly that 77.7% of the citizens who were surveyed believe that anti-corruption or the independent office should not be controlled by government. If it is not, then it means it is going to do a good job. Let me again add that the citizens believe that when they were asked, which office do they believe at this current jurisdiction that we are implementing, who is the best institution to fight corruption? 55.2% of the citizens indicated that the office of the special prosecutor was the best place to go to if you wanted to fight corruption through investigation, through prosecution, and going the whole route. It is not for the lack of institutions, because we see that the second institution was also cited as SHRAJ, because SHRAJ currently has a constitutional mandate, which we have espoused and advocated for over close to 2 decades, if it is not more than that. Samson, an office through this analysis indicated that in its short lifespan has received and is pursuing some 130 cases. Can we, which are corruption and corruption related, the same office which we are talking about not prosecuting and making a toothless bulldog now, as per the ruling of the judge, has between 2024 and 2025 moved from the initial 27 cases to 167 in just a year, because it is now set up. I say in just a year because it is now being fully set up after the initial issues of they not getting the funding and others to set up fully. The same office has within a short period recovered about 35 million of the time and prevented or averted some losses of 7.18 billion Ghana cedis. Are we saying that through what we want to do, and let me say it's not just this government, it started in the previous administration when they realized that the monster they had created was going after them. And I can mention cases here which I don't want to mention. And they also started with the court cases, which has the intention of distracting from the achievement of the object of the office. We have seen that the government itself, which set it up, decided that it had outlived its usefulness and wanted to get them out through some signs of them going to court. But the unfortunate aspect of the whole discussion now for me is the fact that this current government, which has indicated that corruption is a no-go area for them and they would prosecute corruption without fear or favor, is being embroiled in this discussion. I say so because, number one, the president has assured us that corruption remains one of his key 4 pillars that he wants to prosecute. And so, when the majority leader and the chief whip decided that they were going through legislation to repeal the act and so then disband the office, I saw that perhaps rhetoric sometimes, and then sometimes when people concede to issues, maybe they are not believing in. When they have the opportunity, they show their true colors. And this is one of the instances. And again, all the other instances that we are currently talking about, which is distracting the office from prosecuting its agenda, which is per its object to investigate corruption and corruption-related offenses, to investigate corruption-related offenses which have to do with procurement, and then to also ensure that they are working on asset recovery and ensuring that they are also working in preventing corruption is thwarted, is unfortunate. I believe that without a doubt, for Ghana, at this particular time, and for civil society, the evidence continues to suggest that until such a time that we go back to the FIAJO's commission's reports, the APRN, which did a lot of work, which citizens indicated that we needed a select, dedicated body to fight corruption, like the special prosecutor. And of recent, some of the committee that Professor HKP has led have proposed an ethics and anti-corruption office. And something again, let me bring in all the sweet proposals we have put in the NICAP. And NICAP here, I mean, what the president wants us to use to prosecute the agenda of corruption, where he has picked a specific individual to superintend over that in the person of Professor Dodu, who has led the process of developing the national ethics.
The better and popular name for that is Government WhatsApp Group.
Yes, the popular.
It doesn't matter that MPP people are on it. It is all of you have been involved by the government.
And perhaps let's clarify that again to say that the president brought together actors in the governance and anti-corruption space who he believed could put up proposals that would inure to the benefits or inure to the anti-corruption fight in Ghana. And over the past almost a year now, this group used 6 months to put together a document that is supposed to assist in prosecuting the agenda of anti-corruption. And some of the mega proposals include ethics to ensure that we are all working to promote good behavior, to promote conducts. And at the last meeting with the president himself, he reiterated the need to ensure that this is fast-tracked and implemented. So for us to see, and within that document, if I may say, that we have beautiful plans that will help in ensuring, one of the proposals we made there was to put the office of the special prosecutor or write it into the constitution. Because of some of these mischievous endeavors we anticipated or we experienced during the last regime. So the conclusion was that we need a better regime around the fight against corruption. And one of them was also the composite law that brings together everything anti-corruption. And then ensuring that this office is written into the constitution to cure all the gaps and the mischief that is being perpetuated by those who are, who know the law and who are supposed to adjudicate it for the interest of the people of Ghana. It is sad, it is really unfortunate that we are coming to this discussion, distracting from what is happening. We were told that this government is going to fight corruption through oral. We had the Office of the Attorney General through its AG come to us to speak to some of the things it is currently doing when it comes to post-regime accountability. We have also seen the same AG initiate processes that have seen people go because he has the power to do so. But we believe without a doubt that the way the current AG's office is going, it is beginning to look like at the time I said I didn't want this. And so my personal view and personal opinion is that because I didn't want it at the time, but then he came back to prefer some recommendations which you read, including a legislative instrument which has been done and signed. And for us in civil society, we believe without a doubt that the court erred. And we are going to also be working to ensure that that erring we understand, because the law is there for all of us. It's not for a certain group of people to interpret. We believe that the law as it is with its accompanying LI cured that lacuna which you all have been talking to. And I'm very happy to know that some of you here on this platform agree with us in civil society. And we know that in the coming days, we definitely will not let this lie, because there are others, other cases, the Supreme Court one, where the Attorney General has clearly indicated that he believes that the plaintiff is right and is joining him. So perhaps we in civil society and friends of civil society and all citizens who did the assessment on the office and indicated that until we have the alternative, this is the best way to go, would also take the initiative to see how we augment and change this situation without allowing the current status quo, which has been done through the court, to remain same.
But the argument that is going on now, are you not able, including yourselves as civil society, to separate this case from the Attorney General? Because this case, in fact, was brought by one Peter Archibald Hyde, and it was against the OSP, and they were doing their case. The Attorney General had nothing to do with it. I've heard Dr. Kojo Pumpuni Asante. I've heard Edem Senanu of the Africa, the AU advisory on anti-corruption, all say that there are shenanigans that we can't take away. There is a certain turf war between the AG and the OSP. But this is an individual who was doing his case even before these matters, where the AG brought his position in the Supreme Court. Yes, in the Supreme Court. And I've heard Kojo Pumpuni Asante and also Edem and your colleagues ask the question, what is the position of the government, the president? The president's position is known. They tried to scrap the office in Parliament. He said, no, I won't have it.
Samson, the president, that question I have also asked, what is the position of the president? Because we have had occasion to speak face-to-face with the president through the government WhatsApp groupings that we have. And so it really is saddening the way things are currently unfolding. And we believe that the president needs to bring some clarity and finality to this, just like he did when the parliament or the legislature decided to go through the route of repealing of the act through the majority leader and the chief whip. We believe that at this point, the president is the one who has appointed the Attorney General.
The president should have called. The president should have called Archibald Hyde.
Attorney General to order. That is one.
No, the president should have called Archibald Hyde, a private citizen who is being prosecuted by the special prosecutor, and say, don't file a suit challenging the OSP's powers. Then the president should call the judge and tell the judge, don't give him a decision. Is that what you're saying?
I'm saying that is not the case. That is not the case at all. The president cannot tell the individual not to do so, but the president can
admit that the systems are working. The system is working.
No, please, Samson, let me come. Let me finish or let me land. The president's views are those being espoused by his Attorney General. And remember, there is an outstanding case for interpretation in the Supreme Court, which the Attorney General has decided to go with the plaintiff on. And that says a lot. It speaks volumes. That is why we need the president to speak. Again, after the ruling, the glee and the haste with which the Attorney General came out to express himself is quite worrying. And to go to the extent of saying they are putting in place steps to ensure that they take over cases means there is intent, and this intent has been expressed.
You don't want the Attorney General to obey. You don't want the Attorney General to obey the order of the courts.
Or obeying the order of the courts when people are talking about appeals. The office, we know, for instance, that the office of the special prosecutor has indicated quite clearly that they do not agree with the ruling. And when we do not agree, we take steps. And they've indicated same. So what is the haste? Why are we?
But we don't. We don't even know if there are. We don't even know if there's an appeal yet. But even if there's an appeal, the pendency of the appeal or the filing of the appeal does not stop the judgment. The judgment is still in effect.
Samson, we don't discount that, but the haste and the glee with which this is happening and the commentary from the office.
What is the haste? What is the haste when they say we want to take over and then still say in the same breath that they spoke to Justice Fremsai, spoke to Dr. Justice Fremsai, spoke to Joy yesterday and said, we are ready to give the OSP the authorization if they ask for it.
Samson, which authorization? There is no need for authorization for us. We believe that the LI cures that because the former Attorney General, as it has been espoused here over and over again today, signed onto that LI and gave the Office of the Special Prosecutor authorization to carry on with investigating corruption and prosecuting.
Okay, thank you very much, Mary. And somehow you and Kojo have been lucky, because whilst you are the last to speak, you have had more time than the first guys who spoke. You've all spoken like 20 minutes. Let me go to Kenanku.
I'm making an intervention.
Right. Kenanku says, thank you. Lawyer Kenanku says that statutes are construed while constitutions are interpreted. On this occasion, Kofi Bentel is right, respecting how a statute is construed. The reference to the memo, the memorandum to the bill, to see the mischief the provision seeks to cure, that is also spot on. This is a basic principle of construction of statutes. The Constitution, we are told, is a living document that cannot be interpreted slavishly. Is that not the reason why the Supreme Court interpreted a simple word, shall, to mean may? This was to achieve a purpose. Or I am not thinking properly as a lawyer. All right, thank you for that. Because he says I should tell Bafo about that because you are harping on the shall, you know that the Supreme Court has said in a certain circumstance, shall was made. Papa Bisu in Sphincters Accra says, in the first place, the formation of the Office of the Special Prosecutor was in a rush because they didn't take Article 88 serious, really. That's listening to lawyer Ayikwe Otu, former Attorney General and a member of the MPP. Hence, that office was naturally bound to face problems in the future relative to some of their functions because it needed to take some orders from the AG. Yakubu Ibn Chambers in Walewale says, sometimes I wonder, in a crescendo of disbelief, as to why our policy framers would go through lengthy articulation of thoughts to create replication of duties among state institutions. Under no circumstances should the office of the AG attempt to usurp the powers of the OSP based on the wisdom of provisions of the Constitution. There is this popular saying in Chi that the Attorney General must steer clear interfering with the OSP and concentrate on the unfinished works on his desk. Frank Anderson Jr. Says, from what you have read this morning, the debate over the years and the submissions made by your panel, the safest and most sustainable path to ensuring the independent functioning of the OSP would have been through a constitutional amendment, particularly in an environment as politically polarized as ours. We shouldn't be here otherwise. While the Office of the Special Prosecutor is undoubtedly relevant, the current approach appears not to meet the test of time. That's why people are asking. This government set up a Constitution Review Commission. The commission has brought up recommendations. They say write the OSP into the law, even though giving it a different name. So why not pursue the implementation of that rather than join in the Supreme Court and say it doesn't have a power, it should be sort of scrapped. Opokwe J, also a lawyer, says the Attorney General cannot just give a fiat to OSP to continue pending cases. If the OSP has no power to initiate cases, then cases it has started are null and the accused must be discharged. And if the AG wants to prosecute, it must start afresh. Even if OSP is giving the fiat, it cannot continue pending cases. Pending cases, it initiated illegally. All right, it initiated illegally. Fred Simpson Gura, also a lawyer, says, we fail to see why we all advocated for the Office of the Special Prosecutor. We defeat the purpose of the whole act or office if the SP must always go to, if the SP must always go for authorization. In any case, why would the AG wait for the SP to apply before granting the said authorization? Well, we are really serious in our corruption fight. Many of your messages here, and I'm trying to make sure that I capture as many of them as well. Manche Bruce, the second, Takrade says, I'm surprised that the NDC government, which benefited from the outcomes of the work of the Office of Special Prosecutor whilst in opposition, is now taking precipitous steps to dismantle the said office. Reset indeed, amazing convictions. You forget that in the MPP regime, there were also steps to dismantle the office. Don't forget these things, okay? Okay. Please, that's not an argument to have. Excellence reign. Excellence reign.
And the recent petition.
Excellence reign. Please, the OSP suffered a lot within your regime.
Not,
and in this regime
not by
also.
Senior members of
in
our
this
party.
regime, in this regime
Something,
also.
that distinction should be clear.
In this regime also. Gentlemen.
The petition was from Martin Amidu.
Gentlemen, there were petitions from Ken Koranche to the Supreme Court. Ken Koranche is a senior member of the NPP. Has stood for elections how many times?
Not of the same pedigree as the majority chief whip. And the extent to which, look, you are referring to a petition.
Thank you.
Parliamentary processes initiated by the current government to abolish the OSP.
That's an interruption. I'm reading those messages. Okay?
It's deliberate.
And
you made a good point.
And Bafo, to be frank, so Kofi, to be frank with you,
yes,
I've gotten tired of this argument about which is a sound law. I like to keep it to myself, so I moderate the argument as they go.
But we all know the other same.
See, even in this regime,
we know they are the same.
Will you be surprised to hear, that you know that the Germans are helping the OSP a great deal. They are the ones helping them to set up the forensic laboratory. Will you be surprised to hear that the equipment for the laboratory are being shipped to this country, and they wrote to the finance ministry asking for exemption, which is normal for all institutions, and they have been denied. You won't get the exemption. Find your own money to pay for it. So there are a lot of things going on that people read meanings into. They say recently the court sort of the attack. I don't know how to desegregate them properly from government is not involved and all. I tried and it can work. But they say they are pursuing certain cases that people are not pleased with. They are pursuing cases where even national security is involved, in seeking to stop them from pursuing those cases.
But I mean, if government can go, if senior members of the government can go as far as to seek the abolition of the OSP merely because of Mr. Martin Pebu.
No.
Then what else cannot happen?
Why do you think
he came after but it's very fundamental.
Martin
is very.
You may have issues with Martin.
Samson, Martin is my friend.
It's Martin and NDC.
Martin is my friend.
He's not a member.
But he can never divorce the issues. You see, there's a chronology. It was post the arrest of Martin Pebu that the moves were made in Parliament.
That's a
no.
Thank you.
It doesn't mean
excellence reign.
No, but
let me read the message.
There's a nexus.
Thank you.
But it's not causing.
Excellence reign.
No, it's not causing.
Says Ghanaians are expecting so much from the Attorney General, and up till now, nothing to show for the oral cases. You see, it's the same thing we have done to the OSP. When they are prosecuting cases, we want them like. No. It doesn't happen that way. So the oral cases, please, let's stop saying the oral is crashed and all of that, because it is patient. You don't do them in a rush. Thank you.
You are trying to stop.
The young magician.
Forget the press conferences that the Attorney General went on to say that.
You are being disruptive.
Okay, I apologize.
The young magician.
I apologize.
There is no doubt we had issues with the creation of the OSP. if we really want to fight corruption, I believe this is not the route to use to disarm the OSP. The government is trying all means to turn the office into an online shopping store. The trajectory is glaring. Okay, once again, I don't know what to say because, okay, people are entitled to their, what they say. I can't, as it were, muzzle what you say. Please, this case was a certain Peter Archibald Hyde, who is being prosecuted, who went to the court. And it's a fight between him and the OSP, not the Attorney General. Akilu Fantiakwa Begro says, I want to ask, please, has the Office of the Special Prosecutor prosecuted some criminal actors in Ghana so far? Yes, it has, and it has many of them on trial, and 7 or 8 of them convicted. Sergio says, we are going to use another month or 2 to discuss OSP AG matter. Our politicians are very smart. By the time we finish talking, most corrupted ones would have bolted with their goods. Homer says, what at all does government fear that they simply want to get rid of the OSP? Baba Chairman in Tamale says the OSP brought this needless cacophony upon himself. Okay, so you mean the SP, not the OSP. The SP brought this needless cacophony upon himself and the office when he was swelling and went after Martin Pebu, the poster boy of the NDC. From where I sit and the Martin Pebu I know, it's not correct to say he's the poster boy of the NDC. All right, so this is where we take a quick break and return to the arrest of Abronye. This is the second arrest. And then there is Baba Amando, who's also been arrested. I'm sure many of you know what they have been arrested for. How do we draw the line? Where do we draw the line? Free speech and abuse of that right.